Alex here, going live. The video is going, or the live stream is going to be on helping you help yourself. I'm trying to also figure out a better way to send out live stream notifications, not so manual. Right now, people have to go onto my website to look up when a live stream is going to start, and I'm sure there is a way to actually set up YouTube notifications. There's some kind of YouTube actually, if there's a viewer on here who could tell me if they actually get a YouTube notification prior to a live stream, that'd be awesome if you could let me know. Because as far as I know, it just tells you guys when I actually start and not before I start. So one of the troubles that a lot of my viewers have is trying to get specific help. And what I mean by specific is actual statutes, actual rules, actual case law. And I wanted to do a live stream. I've already explained it in a video. In fact, it's called Unauthorized Practice of Law, where I explain why I can't actually do that for my viewers. But I wanted to actually go through this in a live stream and also take feedback, specific feedback from users in the chat as to what maybe they could do to help them themselves through their own case. As I get more viewers, I'm starting to see viewers coordinate and cooperate with each other now. And this could also be sort of a vantage point for how you guys can sort of help each other, because there's a lot of people who are in different states that know more of the particulars of their own state. I would say probably only 25% of my viewers are even in Nevada. So most of my viewers, let's see here. I'm going to pull up my demographics while we wait for more people to join. Let's see. So it looks like we have, at this time, we have 5 viewers. Feel free to participate in the live stream. Right now, all I can do for people who can't chat is let them know that what I'm trying to talk about, I've already discussed in a previous video called Unauthorized Practice of Law. What I wanted to focus on in this live stream was actually helping people help themselves with their own cases, and even giving people specific ideas as to what they might need to look into for their own case. I think I mentioned earlier, less than 25% of my viewers are actually from Nevada. And I'm actually starting to see people help each other, especially people in different countries like the UK and Australia. It would be nice to see if people could help each other in some of the trickier states too. And what I mean by that is Indiana, North Carolina, some of the smaller, well, not even just the smaller, more rural states, just certain states in general just really aren't really caught up to where we are in Nevada and some of the other states with regards to joint physical custody statutes. And there's even one state, Oregon, which makes it so that one parent can just basically refuse joint physical custody and there's nothing the judge can do about it. It's kind of like a veto. So yeah, it looks like 2% of my viewers are from the United Kingdom. 1.5 from Australia. These are 2 jurisdictions that are completely different from the US. I have a few from Canada, 3.5%. Let's see here. So we have 8 viewers right now. Looks like 8 or 7. If anyone has any specific questions on how I can help them with their case, feel free to post it in the chat so I can get started. The live streams are supposed to be more of a back and forth, more interactive. I try not to just go into monologues on these. I can just do that in a video. For anyone who hasn't seen the videos, statutes, rules, and case law, and research, definitely look into those videos if you're trying to figure out how to do your own research for your own case. If anyone doesn't understand why the viewers of this channel have to kind of do their own research, please check into the video Unauthorized Practice of Law. All it really states, or all I really talk about in the videos, I can't actually do the work for people. Providing examples of what I've done before, like some people have asked in the past for motions that I've filed, orders that have gone from the court. Those are things I can do because all I'm really doing is showing you public record, showing you a document that's been filed in a court. And then people can draw their own analogies from those documents if need be. But let's see. I also just published a video, so I'm actually getting notifications on that video. The video I just published is Best Interests of the Parent. Let's see here. What I basically talk about in that video is how sometimes judges, attorneys, and even the parents themselves get distracted with the best interests of the parents. What I mean by that is not necessarily so straightforward. One good example of it might be a parent who is frustrated with what the other parent is doing, but they don't want to take action against them because they feel bad for them. That's an example of putting a parent first, doing something not because it's best for the kids, but it's just because you feel bad for the other parent. That usually comes up in situations where the other parent is abusive or neglectful. It often happens with the court when they focus on settlement to the point of even obsessing over it, just trying to force the parties to just come to an agreement. It ends up sort of taking the focus off of what's best for the child and assuming that whatever the parents agree to must be best for the child. It's not necessarily true. In fact, especially when the court is twisting arms to get parties to settle, often one parent who has protective concerns just gives in. And so that can be an example of the court focusing on best interest of the parent. It's a good video. Definitely take a look at that if you haven't seen it yet. So I'm probably going to end this live stream early. It doesn't seem like I'm going to even reach 10 viewers right now. Probably in about, I'll wait another, let's say 7 minutes. If anyone has inputs on better times to schedule live streams, definitely send me an email at admin@theproperperson.com. That I figure Saturdays and Sundays are best. And with respect to times, I've done 6:30, 4:30, 5:30. I've kind of bounced around. I think the earliest I've done is like 1 or 2:30 before. So. One of the things that's going to help people, I think, work on their own cases is when I start the My Docket series at 3,000 subs. Each time I post a video in the My Docket series, I'm also going to attach a link to the actual filing that the video is talking about. Each video is going to cover a filing, and I haven't even really tallied up how many total filings that I've made in the courts, but I imagine there's going to be at least 100 videos. And I'll be able to show people sort of how I went through the process from the beginning to the end. And then at the same time, people will be able to look at my filings. And they're not the best, especially the ones in the beginning. The ones later on towards probably the last year are the best filings. But at least it'll give people something to relate to when it comes to what does it look like when you're representing yourself in the very beginning. And sort of seeing that I went through what everybody else went through as well. I'm still thinking about whether or not I'm going to actually post snippets of my hearing videos. I'm really on the fence about that. Some people think it's not a good idea because the information is private, and that's true, but almost everything on my channel has basically made my case public as far as, at least as far as the paperwork goes. I'm not sure that the hearing videos would be a much further step. And there's already a lot of hearing videos online anyway, so it's not like it would be the first time somebody's ever done that. I'm leaning in that direction though, and I think as much as people like examples of filings, people would like to see examples of the videos as well. You can also send me emails at admin@theproperperson.com if you have some kind of input on that as well. But I'm on the fence about it. I'm leaning towards providing copies of my videos and actually going over them in a video and sort of critiquing myself. And again, that's going to show people that I wasn't some kind of genius in the beginning and that I struggled just like everyone else is struggling and that I wasn't very articulate. It's important, I think, to make it clear to people that I didn't just get lucky and get the outcome in my case, which was primary physical sole legal custody and then determination of my ex's parental rights. I didn't just get lucky and get like the best judge ever and just miraculously get past what everyone else couldn't get past. I actually stumbled around and struggled, especially for the first 3 years. Not as much, but I still struggled through the next 3 years after that. Then I had like 1 year of peace and quiet, and finally 1 more year of litigation for the termination of parental rights. So I'm going to probably log off of this live stream in 3 minutes unless we have some kind of interaction. And I'll just reschedule 2 weeks from now. Probably on a different day too, maybe like a Friday or a Sunday. All right, guys. Well, thanks for logging into the live stream. I'll probably set one in 2 weeks. I hate to say it, but I don't do live streams just to go into a monologue. I can just do that on like another video. I try to make these more interactive, more back and forth. I try to look into how I can reply to people who need help right now, going into the comments and such. But at this time, there's probably a lot of people just on phones watching. There probably isn't anyone who has a keyboard. So, oh, whoa, hold on a second. Hold on, there's a ton of people. All of my chat just popped up. Weird. That's probably like a bug. Let's see. Let me start at the beginning. Everyone's probably wondering why I was talking about logging off so quickly. All right, guys. I see the chat now. I don't know why that happened. Isaac Gomez. Hey, how's it going? Kelly S. Think my husband and I got the notification that you were live in real time. See, that's what I'm trying to avoid, Kelly. I'm trying to get it so that you guys actually know. Somebody just tried to call me. Oh, okay. Yeah, I'm going to figure out how to make it so that you guys get like a notice probably 15 or 30 minutes in advance. Right now I have it on my website. So, JS, no, I don't know anybody in North Carolina. That comes off the top of my head. I know that I do get questions from people struggling in North Carolina, though. Let's see here. Rachel loves the channel. Thanks, Rachel. Let's see. So JS says attorney is transitioning her case, third attorney, and doesn't have money for another attorney. What does he mean by transitioning? Sounds like you mean the attorney just wants to get off your case. Yeah, every time that happens, you end up having to pay another retainer. And there's like $1,000 worth of money that's just thrown away on them trying to figure out what happened in your case. So, you know what, especially on $12 an hour, if you can't hire another attorney, you're just going to have to represent yourself like most of us are doing. I hate to say it. You can try to get free attorneys, but most people can't. Some people in some states get a free attorney by alleging domestic violence, and then they go to like their legal aid clinic and get a free lawyer that way. But that gets abused a lot, and some of the clinics are starting to get wise to it. Love and Life says she has a question. What do you do when both parents agree to meet at a certain location after the other parent was allowed to relocate and that parent refuses to meet up for the exchange? That's why it's so important to get that into an order. There's a lot of parents who don't get that into an order and then they try and work it out. With some parents, it works for a while and it breaks down halfway through. With other parents, they just can't even agree right from the get-go. Usually, it's good to talk to the court about that when somebody is actually relocating and have the court, because, okay, most judges with experience will actually take care of this even if nobody brings it up. But some of the judges who don't have experience don't think about this. And so it's important for you or your attorney to bring up that you need to set the actual place for where you're going to exchange. I think, let's see, if one parent does not, so if you have like a non-custodial parent and then a primary physical custodial parent, I think it's best for the non-custodial parent to have to be the one that figures out how to get the child back, because otherwise, if it's the primary physical custodian, if it's the primary physical custodial parent's job to do that, some of the things I see in high conflict child custody cases, when that happens, the primary physical custodial parent will either go and try and pick up the kids, or they'll try and like pay for a ticket to have the kids flown back, and then the high conflict non-custodial parent will come up with some excuse, and it won't happen, and the kids won't be able to get back. And it causes all kinds of chaos if the primary physical custodial parent drove all the way there, and now they're stuck in another town, and they have to figure out if they can get their kids or not, or whether or not they're going to have to go back and just file a motion in court. Or sometimes, like when it comes down to flights, the primary physical custodial parent may end up getting strung along and paying for 2, 3, or 4 flights. I always think it's best for the court to make it the non-custodial parent's job to figure out how to get the kids back. Because that way, if they're not doing it, they can get held in contempt of court. That sounds like that's what he's going through, or at least that's what JS is going through. Hey, Megan, I'm glad you caught me live this time. Yeah, JS, I didn't think North Carolina was a 50-50 state, and if it's not, then it becomes incredibly difficult to figure out how to approach the court on equal footing, because frankly, there isn't equal footing. There isn't. I talk about it in the video, gender bias. I would recommend you watch that video first. If you have any specific comments, post them in that particular video's comments, and I'll get back to you. But you have to do what you would have to do in a state that has 50-50 presumption. You're going to have to present your case. It's going to be difficult because most of the time when there isn't a 50-50 presumption, most of the time, unless there's something wrong with the mother ends up getting custody of the children. It's sad, but it's the reality. You can try to do the best you can to put on your case, but what I mean by the best you can is encompassed in like 25 different videos. It's not something that I can just go into, because there's so many little teeny tiny pieces that when it comes to actually fighting your case. There's discovery, there's the initial pleadings, there's what to do at a hearing, there's figuring out what type of hearing you're even going to. There's a lot more to it that I can't just say, with a paragraph or two. Kelly, is there any precedent for a physical custodian to have a lease or a place to live in? Not that I know of, actually. I've seen physical custodians who just live with their parents get physical custody of the kids. There isn't any precedent that I've ever seen. There's something that I'm sure a judge will consider, but if a judge considered it and decided that they're still going to let the kids live primarily with somebody who's living with their parents or something like that, I wouldn't be amazed or even surprised if you couldn't do anything about it on appeal. I wonder how far that could go. Like, I wonder what would happen if a judge gave primary physical custody to a parent who lived in a shelter, like a homeless shelter. But even then, I'm not sure that I would be that surprised if the non-custodial parent could do anything about it. Like, if they had some kind of conviction for domestic violence or something like that, the Supreme Court or any other appellate court might affirm and say, yeah, it's a shelter, but the other parent's worse. You should watch the video Standard of Review if you're asking about precedent to the extent of filing like an appeal, because that video talks about the constraints an appellate court has in intervening on your behalf against the trial judge when the trial judge does something that you're not happy with. And in your case, what you're talking about is letting the kids live primarily with a parent who doesn't have a lease. JS, how do you get the NARC parent to give up their parental rights? Narcissistic personality disorder, I assume that's what you're talking about. They're not like robots. There's not an answer that applies to all of them. They're people. The disorder has a kernel and a consistent sort of root that they all are kind of afflicted by. But the way it manifests in each different parent who has narcissistic personality disorder makes it so that they could react in wildly different ways. Some of them may not even want to go to court and just not care, and voila, you've got your kids, and they terminate their parental rights really quickly just by abandoning the children and letting a TPR go through. and other ones may fight tooth and nail, and you may find yourself litigating, you know, a vicious TPR petition. There's no straight answer for that. Kay Nelson, same problem as everyone else. Let's see. Megan Watson on watching the replay. What do you mean? JS wants to know how long I was married. I wasn't married to my ex. We were together for 3 years. Yeah, we weren't married. Flyboy C. Hey, Alex, UK here, wishing you well. You didn't miss it, actually. I just started. I just thought that nobody was chatting because my chat box wasn't filling up. And then right when I was about to go away, all of a sudden it populated with like 40 different chat messages. No, I was not ignoring you guys. Love and Life says, no, don't leave when we have questions. Yeah, I'm seeing them now. I'm so sorry. Not my fault, though. Kay Nelson, together 16 years, married 12. Are you talking about your ex? That's my question to you. Flyboy says, what can you do, either case law or common sense? Common sense doesn't go very far in court. When you have to break a court order, but you do so in line with the child's best interest. This is a great question, actually. Flyboy C, contempt of court has 2 very major, I guess we can call them analytical prongs or elements even, that have to be satisfied. The first is your ex has to show that, and I'm just talking about high conflict child custody right now. This is actually kind of this is a basic thing with contempt of court in any type of case. The first thing that has to be shown is that you violated a court's order. If they can't show you violated a court's order, that's the end of it. It doesn't go any further than that. Even if your conduct is outrageous and is very harmful to the children, they cannot hold you in contempt of court. They can do other things to you. They can try to modify custody or, you know, do something like that. I talk about this problem or dynamic in the video, Many Fine Lines. But after they show that you violated a court order, there's a second part of analysis, and that is whether or not you did it for, by the way, let me clarify earlier. Violating a court order on purpose, deliberately. Sometimes there is certain situations when it comes to certain court orders that can be violated and you didn't mean to do it. I don't really have any, maybe one specific might be you were ordered to provide the children health insurance and you got terminated from your job for some reason or laid off. That's an example of a court order that may have been violated, but you didn't do it on purpose. That's what I wanted to clarify on that first part. Second part is they have to show that, or you have an opportunity to show that you did violate it, but you had a reason. And so you could, in theory, violate a court's order. Let's say, and this is going to be an obvious example, but you can take this example and sort of extrapolate it to your own situation, hopefully. An obvious example would be that you're supposed to exchange a child at 3 o'clock and at 2:30, all of a sudden your child has projectile vomiting. And so you go to the hospital. You violated that court order because you didn't go and exchange the child, but you also have a justifiable reason for doing so. You had to take the child to the hospital because you don't know what's wrong. Suddenly they're really sick. So this is really, really a risky thing to do because in this situation that I described, it's obvious. No judge is going to hold you in contempt of court for that. But other situations where people have what they think are justifiable reasons are a lot closer to that fence where it could go either way with the judge. And it's not really necessarily at each person's fault who's in that situation as much as it is the fault of all of the bad parents who are just looking for pretexts or reasons to deprive the other parent of visitation. The judges end up getting jaded. And so because of that, you have to be really careful. What you think is a justifiable reason to violate a court order may not be a justifiable reason in the judge's eyes. So, I mean, if you give me a more specific example, I'll try and cover different angles that might come up in your situation. But I didn't get that from you in your question, so I'm going to move on to some of the other questions here. It's good to see you guys talking about North Carolina. There's it looks like 3, maybe 2 or 3 of my viewers on the live stream are from there. Let's see. Jays says, do courts typically frown on a parent that continually refuses to respond to any matters concerning the child? No co-parenting whatsoever. That depends a lot on what's being ignored. So and this question has come to me from both sides, from the high conflict side and from the normal parent. You are entitled to a response in your communications if they make sense. If you're talking about, hey, let's set an appointment for our child to go to the optometrist on this date and time, yes, you're entitled to a response from that, at least initially. But if you get a response and you don't like the answer, then you send the same question over and over again, you wouldn't be entitled to a response to a question that's already been answered. If you send some kind of communication like, I think you're a piece of crap parent, you're not necessarily entitled to a response to that. That's just a communication that conveys hatred or whatever. It really depends on what you're trying to communicate to the other parent. If you give me a more specific example, of what you're actually trying to communicate, I can get back to you better. But there's a lot of high conflict parents who send, and I'm not saying you are one of these because I don't know you, but there's a lot of high conflict parents who send nonsensical communications that are argumentative. What I mean by that is they're not actually trying to communicate information about the child. They're just trying to start a fight. There's people who send communications that are trying to like build a record. And so that's not really what you're supposed to do when you talk to the other person. I actually talk about this in a video called Communication. There's some parents that send communications that are just trying to trigger some kind of reaction. So it definitely has to be about the children, and it has to make sense. And oh, here we go. Oh, I see, Megan. Yeah. I'm glad I didn't sign off. That would have been really sad because everybody would have been talking to me, and we got Ecclesiastes here. Narc ex-wife and Narc grandmother started stepping on my time with our daughter. What is the name of the court form I need to file? And is a letter from a lawyer to them to cease and to cease? I think you're saying to cease and desist any value to the court. Well, of course, anytime you're trying to hold somebody in contempt, well, first off, you're asking what you need to file. In Nevada, it would be a motion for order to show cause. And inside of that motion, you would be alleging that the other party is violating your custodial time, which is in the order, so they're violating a court order. And they have no valid reason for doing so. It's also going to require points and authorities. Definitely watch the video Motions if you don't know what I'm talking about. Other states, by the way, I've started to find out, like for example, Indiana, they don't actually want you to file points and authorities in your motion. I'm not sure why, but that's one of the reasons I'm doing this video, is for people who are trying to figure out how to help themselves, to hopefully find other people who are in some of those other states where things are trickier, or not even just trickier, just different. Anyway, the point is, at least in Nevada, it's a motion. Some states don't even have formal motions. Some states just have forms, like in Colorado and California. And they may still be titled motion, but most people don't see it as, an actual formal legal motion. They just see it as a form you fill out, like an application for a job. So you have to figure out what it's going to be called in your state. I can at least tell you what it's called in mine. It's a motion for order to show cause. Yes, if you're trying to hold someone in contempt, it's always a good idea to send a letter before you do it, because it gives the other side a chance to explain themselves. And when you go and try to hold your opponent in contempt of court, one of the biggest things that a family judge is concerned about is that you're just trying to use the court as a weapon to get back at your ex. So the more that you show you gave them chances, you gave them a chance to explain themselves, a chance to fix what they're doing, a chance to give you makeup time, for example, for having taken the time you're supposed to have with your children, the more you show that, the more you don't look like a parent who's trying to get revenge. And if you don't look like a parent who's trying to get revenge, the court is a lot more likely to hold your ex in contempt of court. If they think you're trying to hold him in contempt of court because you just want to get back at them, they're going to find every reason that they possibly can to deny your motion, even if you're actually being frustrated. So I actually talk about that in the video Gotcha Litigation. Mariusz says Alex is the best source of information for the family court issues. He should be an attorney. I would vote for that. Can I file such a petition to one of those anti-family courts? Yeah, I've helped Mariusz with his case. He's actually in Nevada. He's had really positive outcomes. He does a great job preparing his own papers and pleadings. Mariusz, I don't know what you mean by anti-family court. Like a court that isn't a court? I'm not sure what you mean. Please clarify. I don't think you can just vote me into being an attorney. Megan Anenga says, regarding support, ex just missed a hearing by going to Arizona. Claims another kid of his is having medical problems with no proof. Judge served a bench warrant for arrest. He's skipping does skipping the state affect things? My understanding is that it doesn't, because all 50 states have, what do they call them? Extradition. I don't think, they're not really even treaties. I have a feeling this is handled at the federal level. And the states are bound to some kind of formal process to extraditing people that they arrest under warrants from other states. I'm not sure how it works for misdemeanors. So it would be an issue if like it was a misdemeanor ticket. Possibly you wouldn't be able to see him brought to justice. But bench warrants are different. Bench warrants have nothing to do with arresting for like a crime, like a misdemeanor or a felony crime. Bench warrants will be executed in other states. In fact, there was one in Nevada that was high profile. It was in the news like 2 months ago, I think, 2 or 3 months ago. It was around Christmas time. It was on KTNV. It was a parent who abducted a child to Tennessee. Allegedly abducted a child to Tennessee. I know she's facing criminal charges right now. And the family judge issued a bench warrant for her arrest. She was arrested in Tennessee by Tennessee police. And they extradited her back to Nevada. And now she's facing charges in Nevada for crimes. So she actually got an arrest warrant and a bench warrant. But I think they arrested her on the bench warrant, not the, I'm not sure. I don't think they arrested her on the criminal charges, because I don't think they're considered felonies, but I may be wrong. I know that the family judge definitely issued a bench warrant and a pickup order, and I know that that was executed on. So going to another state isn't going to save him. Kelly S. Let's see here. When we were in North Carolina, oh, they're talking. You guys are talking to each other. That's great. Cordell and Cordell, I've heard that name so many times. I'm starting to imagine that this is an attorney that's in all 50 states. I haven't heard only positive feedback from people who've hired Cordell. I've heard mixed responses from people. Some people think that Cordell doesn't really care about fathers' rights and he just wants to cash in on it. Other people said he was great. So I just be careful, because it's not a silver bullet that's going to definitely solve all the problems in your case. Definitely look into it and research it. Jay says, do good attorneys typically level with their client, whether or not they have a good chance or a bad chance? Yes, the best attorneys will do that. And they're not totally rare, but I will say that they're uncommon. And the reason why is explained, I think I cover it in my video, Win at All Costs, but I'm not sure if I do now. What I'm going to just say is this. There are some attorneys who just want to take your money, and they'll just tell you have a great case even though you don't. And then there's other attorneys who they feel bad, and they'll tell you if they think they can't win, and they won't take your money because they want you to know the truth. And if you insist, they'll represent you and they'll take your money. But if you take their advice that you don't have a good case and walk away, then they're okay with it. Then there's these attorneys in the middle, and these attorneys believe that, yeah, you don't have a good case, but they don't necessarily want to just send you away, because they think you're going to just go and hire another attorney anyway. And since another attorney is going to get your money for a bad case anyway, they may as well just take your money and represent you themselves. In other words, they may as well just take your money if you're going to give it to somebody. That's something that, I mean, they're not going to tell you that to their face. And I'm not even going to say that any of them have told me that to my face, but that's the general vibe that I get from the industry, is that there is this kind of mentality that from some lawyers, from most lawyers even, that there's no point in telling you can't win, because you're going to just go and hire somebody else anyway. And so they may as well just pocket your $5,000. I hate to say it, but that's the truth, I think. Isaac Gomez, Alex, do you speak Spanish? Yes, I do, but I'm not fluent. I would say I'm almost fluent. It doesn't help to be almost fluent. It's obvious when I don't know a word and I have to stop. So I can get through like 3 sentences perfectly and sound like I'm a fluent Spanish speaker, and then not know a word in sentence number 4 and like sound goofy. So I mean, I can get by. I usually warn people in advance. I tell them, hey, I can speak Spanish. It's not perfect, but I should be able to communicate with you. And then they'll, we'll go forward in Spanish. Kelly says, or Kelly's communicating with Jays. Yeah, Jays, communicating on school programs, the child's well-being. Okay, I wouldn't do that. The child's well-being, that could go out of control. You could talk back and forth about the child's well-being every day, and some parents don't want to talk to you. They want to just only communicate about the bare minimum, and they may not want to talk about that. If the child is sick, like they have the flu or something, yeah, they should tell you that. But if the child's doing fine and there's nothing to say, and you send communications, hey, how's the child doing? It could irritate them. They could decide, you know what, we're not together anymore. I don't want to talk to you about this. I'll let you know if the child is sick. So something like that, I think, is going to be something that the court doesn't care about. School programs, well, I don't know. You know, if you're asking about whether or not the child can go to a club, and you should probably get an answer to that. That wouldn't be in the best interest of the child to ignore a question like that. But if you get a no or two no's and you keep asking about different programs, different clubs, the parent could become frustrated and just not want to talk to you anymore about it. So these aren't things that are really clear communication issues that I'm going to say a court's going to get upset about, especially if they have a justifiable reason. Kelly says, he has always been frank and forthright and upfront. Yeah, that's a great attorney. I've had those before. One of them told me I was going to lose, and she was wrong. She represented me anyway. She said I had brought five issues to her. I'm trying to remember what the 5 issues were. Relocation to Las Vegas from Reno, reducing child support to a judgment, reducing medical obligations to a judgment, modification of physical custody, and then there was a 5th issue, and I can't remember. Anyway, she said I was going to lose the modification of physical custody for sure, and she said that I had she said I was going to lose the relocation for sure, and that I had a very small chance of winning the physical custody motion. And she ended up being wrong, and I won on all of them. I appreciate her and other attorneys for being frank and upfront, and I especially appreciate that even when they think you can't win, that they still go and fight for you. These are rare. These are litigators. But yeah, it's great when your attorney levels with you and tells you that they don't think you can win. That's honest. It's important. Luckily, in my case, I countermanded her and said, go ahead and fight it anyway, and she ended up winning. So that was great. Let's see. Message retracted from Megan. I wonder what that message was. Let's see here. Pyriute says, can we get the web forum going? I need help. Pyriute, I'm going to do that when I have more subscribers. Let me check how many I have planned really quickly for that. That's on my list. I don't want to do it too soon because it's not going to get used by enough people to justify all the work. It is going to take a tremendous amount of work. At 10,000 subscribers, I plan to share a docket system. When that's going to happen, probably 9 months from now. The progression of subscribers, from what I've seen, is you get from what I'm being told, a lot of people get from 1,000 or 2,000 subscribers to 8 to 10,000 subscribers within a year. And then I'm planning on doing the interactive forums after I have 20,000 subscribers. So you're looking at probably 2 years from now. I'm trying to space out when I deploy these features because it's a lot of work. It puts a tremendous amount of strain because I'm already doing so many other things. And so I kind of have plans to do these things, but I want to wait till I have a larger audience so that it's actually used a lot, not just a little bit. Love and Life says, this isn't really a question, more an annoyance. When a motion is filed, the opposite party will file a response after the time allowed. Yeah, they're not supposed to do that, but they get away with it in family court. And the reason why is because there's these cases that have published in Nevada, and I'm sure other states have them too, that explain and emphasize that the appellate courts want the family judges to, whenever possible, make a decision on the merits of the case and not make a decision on a technicality. And that's what they consider a decision. If a decision went one way because the other parent didn't file a response on time, that would be what they consider to be a decision based on a technicality. It's not based on the merits. The judge decided to not read the merits because the other person didn't follow the court rules and made a decision based on violating the court rules. This is not just something that frustrates you. It even drives lawyers nuts. It drives them absolutely bonkers. There's lawyers on all kinds of lawyer forums in Nevada that complain about this, and they complain that the judges don't follow the rules of civil procedure and all that. I don't know what to tell you because on the one hand, you should follow the rules. You shouldn't be filing late responses. But on the other hand, the argument that the appellate courts makes that they don't want kids to suffer because the parent was a knucklehead and didn't follow the court rules, that also makes sense too. So it's one of those things that's just kind of, Usually I see judges in the family division give the other side an extra week or two. My judge often gave my ex 3 or 4, maybe 5 or 6 weeks sometimes. I'd file a motion and the judge would wait 2 months to file an answer, to file her order. So it depends on the judge, sadly. Ecclesiastes says, Alex, Narc X and Nargram have started signing up our daughter to activities on my time. Oh my God, this is in Nevada. I've seen a lot of judges get very angry when their exes do this. You cannot schedule, like, you cannot like create a reason why the child can't go see the other parent. You can't just be like, I enrolled the child in soccer, so now you can't see the kid ever because they're just going to go to soccer on your time. You can't do that unless you have a really, really green rookie judge. That's probably not going to go well for them. They do not like when people do that. You need to get that thing resolved. You need to bring that to the court's attention. If they scheduled an extracurricular and they're using that to deprive you of your custodial time, you're going to need to get that taken care of in court. You may need to file a motion for order to show cause and have been held in contempt of court. I've seen it happen, and the other parent is baffled. Like, they can't believe they just got held in contempt of court for enrolling their daughter in gymnastics and saying that's the reason why she can't see her dad now. It doesn't work on most of the judges, especially the ones who have some experience. It's a very common tactic that's used by a parent who wants to deprive the other parent of their custodial time. Megan Anenga says, something I found said skipping state moves a misdemeanor to a felony. I've never heard of that, Megan. That doesn't sound right to me. Unless you're talking about, I don't know, child abduction or something like that, that's possible. But if you're just talking about generally, like if a person shoplifted from a store and got an arrest warrant issued for that misdemeanor crime, and they just like left to Texas or something, I don't see why that would magically transform into a felony. Pyreute says fathers' rights firms are not. Yeah, a Pyreute, it's a disturbing thing I've noticed, and it's not even just with firms. There's even organizations who claim to be fathers' rights organizations, and then they charge parents for like fathers, they'll charge them for forms and stuff, and they end up just fleecing the fathers. So that's one of the reasons why I'm not doing coaching on this channel. I mean, I know that I've said I'm not doing it because of unauthorized practice of law, but I don't need to fleece people when they've already been fleeced by attorneys and other organizations out there. Let's see here. Kelly says, thanks for your response about residence and leases. We already have primary custody, so only 8 to 9 nights a month. Is this an issue? Oh, so you're saying the non-custodial parent. You know, all I can say, Kelly, is you have a right to know where your child resides, at least in Nevada, because I just got published on that issue. Well, not just published, but the Supreme Court did answer a petition for writ of mandamus I filed where that was the issue. I wanted to know where my ex resided. At the very least, you have a right to know where they reside. So if they are at a shelter or living with their parents, you at least have a right to know it, to know that that's what's going on. Megan Watson, what are your suggestions about holding high conflict ex accountable for public defamation and harassment online? My suggestion is you can't do it that way. You cannot take it to your family judge. You can't. You just can't do it. You have to file that as a separate lawsuit, and it has to be a lawsuit that is based on defamation of character, slander, or libel. But the problem with that is you can't just do that and expect to win. You actually have to research how defamation of character, slander, and libel work. And you actually have to see if you satisfy the elements of those claims. If you don't, then you can't do anything about it. I talk about it in the video titled Slander, Libel, Defamation of Character. Take a look at the video. The only exception I would say is if your ex is slandering you to the child, because that's different. The courts consider that to be disparagement. That's the word they use in Nevada. Disparaging the other parent in front of the child, and that's a best interest issue, and that's possibly a contempt of court issue. And I actually covered that in a video titled Non-Disparagement. So you could look into that too. A lot of people have that question. A lot of people want to deal with defamation and harassment and all that, but you can't do it in family court. You have to file that as a separate case. And you have to make sure that you do your research, because a lot of people think that slander and defamation in and of itself, like the dictionary words, is enough to win those lawsuits, but it's not. Those are complex. You have to prove like 4 different elements, and one of them has to do with how were you even damaged. Because if you just say random people heard and read about it, well, that's not good enough. You have to show how random people read about it, that they believed it. You also have to show that it's some kind of factual assertion, that it's not an opinion. You also have to show that you were damaged in some way. So usually you have to show that you lost work, like you couldn't get work or something. It's not that easy to do. That's why so many times those claims work against newspapers and television channels and not so much against just random people. And the courts do consider your ex to just be some random person. And also then you have to deal with the problem of what if it's the truth? Because truth is an absolute defense to libel and defamation. If somebody's telling the truth, even if it's ugly, there's a whole lot that goes into it. They're very complicated. And people try to deal with it as just a really simple issue. My ex is lying about me online, and it's way more than that. But Ayush says, I want everyone here to know if family attorneys and judges would be so pure-hearted like Alex is, it would not be any problems with custody conflicts. Make the family courts great again. Yeah, Mariusz, you should see, I don't know if you've seen this before, my video, Gender Bias, and especially my video, Discretion. I talk about these two huge problems that actually, I think, lead to why so many of the other family judges are not even going to say different, they're just completely random almost in how they deal with things. And I do think a lot of them have a pure heart, but they're ignorant about child psychology. They're ignorant about personality disordered parents and mental health issues. They're ignorant and they have no idea as to how people with messed up heads think and work and how they have completely different objectives. And most of them, I don't think they're evil or even malicious. They just don't know what they're doing. And because they don't know what they're doing, they make mistakes, and the mistakes actually hurt parents and their children. Kelly says, I think picking a good attorney is like dating. It's super subjective and can change over time. Yeah, I talk about that in my very first video, representing yourself. And actually, I don't talk about picking attorneys, though. I talk about how deciding to represent yourself is a question that changes over time. So in a way, it's just from a different perspective. With you, it's deciding and picking an attorney. With me, it's deciding whether or not you're going to represent yourself. But yeah, it is subjective. It's different with every person, and it does change over time. It really does. These people retracting messages. Here's another one. Precious Regalia retracts. All the secrets. Okay, love and life. What can be done in court about a parent who constantly calls the police while the child is in your care? Calling the police for wellness checks when after they just spoke to the child 15 minutes prior. That parent has probably got a personality disorder. Nuts do that. Just total nuts. You're going to have to figure out how to prove it, though. Different judges deal with it in different ways. The experienced judges do not like when the cops are called. Unless you're getting some kind of communication that your ex is going to kill your child, the judges don't like it. Other judges are complete noobs, and they're like, well, if you were scared, call the cops. They don't understand how high conflict parents work. High conflict parents will take that advice and call the cops every 2 hours, thinking, hey, the judge said I can call you. Yeah, you need to figure out how to bring that up in court. You may want to try and allege that your ex has some kind of mental health issue and see if the judge will subject him to a psychological evaluation. But that's not always the best way to go. Instead, what you might want to do is see if you can pile up a list of other things that your ex is doing. Usually if an ex is calling the cops every 15 minutes, they're usually doing a whole bunch of other abusive and neglectful things. And it's a matter of figuring out what they're doing and how they're doing it. So like in my case, my ex was, there were so many things. Okay, what I'm going to say is this. When I thought my ex had a mental health issue, I decided against deciding to ask the court to have her evaluated. And what I did instead was came up with a list of the problems that I wanted to use to modify custody on. And with her, it was dental neglect, it was not taking the child to school, and it was all of the high conflict messages. So I decided, and I talk about this in the video, evaluating mental health. I decided at one point, you know what, my ex has a mental health issue. And once I decided that, I was like, how am I going to deal with this? I had two choices. And like I mentioned, one is to ask for an evaluation. The other is to just try to modify custody based on all of the symptoms of their disorder. I chose door number 2, and it worked. I talk about how I was successful in the video modifying physical custody. If your ex is doing crazy things like that, they're probably doing other crazy things too. You just need to figure out what those things are. You probably already know what they are. Talk to the teachers more. Figure out Oh, I need to move on from this one. Hold on a second. A Pyriute says, I mean, do you need help? I have administrative experience. A Pyriute, oh, that's the little symbol next to your name. You must be a member. Okay, so yeah, my channel was approved for memberships way early. YouTube has this thing called channel memberships. I did a video on this. You're supposed to be eligible at 30,000 subscribers. They gave it to me when I had only 2,000 subscribers. Honestly, I think it was available to me much sooner, but I didn't sign up for it. I think I got it around when I had 1,600 subscribers. So now we have members on the channel who are becoming members. That's why their names look different. They have those little symbols next to their names. I'm not sure who you're at. If you're asking if I need help, if you're more, oh, you mean about the forums. If anybody was going to help me, it would be a software developer at this point. It would be, because it's going to be a lot of code. I'm not going to just make a forum out of just a random pre-built module or something on the internet. I'm going to write my own forum and I'll attach it to theproperperson.com. Precious Rujalia says, my ex says I get no information, only bills. Well, that's not true. Not under the law. I have a video on ex refuses access to medical care. I think that's what it's called. I went through that in my case. I had to file 3 different motions to have my ex forced to tell me the information regarding my son's medical care. Yeah, definitely watch that video and I tell you how I dealt with it. But basically, it was me filing motion after motion after motion. And finally, when I filed the 3rd motion, the judge closed all of the gaps and loopholes in what she was doing. I was able to get 2 weeks notice whenever there was an appointment of any kind. There's a lot that went into that. It wasn't even just the appointments. I was trying to get the benefits cards. I wouldn't get the benefits cards from her. LC, let's see here. Yeah, I'm going to just agree with Kelly on what she's telling Megan. Cease and desist letters do matter later on when you file a motion, because then you can attach that letter to the motion. You don't even have to send a letter. You could just even send an email or a text. Email would be better since they print better. Just saying, you know, this is what you've done. How are you going to fix it? You know, if your custodial time was deprived, you could say, what was your reason? Why did you deprive me of time? And you could say, am I going to get makeup time? Even if you know your ex is going to say no, at least send the message so that way you can attach it to an exhibit so that the court can see you in writing. The court can see that you're not just trying to get them thrown in jail for contempt, that you're actually trying to resolve the issue out of court, that you actually gave them a chance to give you more time to see your child, and that they still refuse. That's how I was able to have my ex held in contempt of court. In this case, in this situation, it was she refused to exchange my son's homework package. Yeah, a Pyriute, I have definitely got ideas on it. I'm going to be breaking it down by state even, so that people not only discuss attorneys, but they can also discuss the rules and statutes specific to their state. I definitely have the plans to do that. When I decide to go and get, when I decide to start developing the forum, I'm going to keep you in mind so I can get input from you and probably a few other people, probably a handful of other people on how we should design it and how it should work. But you're probably going to see the docket sharing program first. So you won't really have any forum, but you'll at least be able to share your documents with each other. And once that's established and I get to 30,000 subs, then I'll move on from that and set up a forum. Kelly says, oh, yeah, your ex isn't doing his or herself any favors with the police calls. There's a record of that and it makes them look bonkers. It really does. Especially if it's multiple calls. If it's just 1 or 2 calls, it's not as bad. But if they've done like 10 or 20 calls to police, that should send a message to the judge that something is wrong with them. Prevent PA says, hey, Alex. Hey, how's it going? LC, looking for high conflict firms, not father's rights firms. Yeah, that's the smart way to look at it. You know, every time one of these coined phrases pops up, though, these attorneys, they just jump on it. So like when the term father's rights was a thing, all these firms popped up calling themselves father's rights firms. You're going to see firms that specialize in narcissistic exes soon. I feel like it's coming. And yeah, this high conflict child custody thing, I never used to hear this phrase. And all of a sudden, 4 or 5 months ago, I started to hear lawyers and judges use the phrase high conflict child custody. I don't know what was going on before, like years ago. I never heard that phrase from any judge or any lawyer. So I wouldn't be surprised now if you start to see attorneys start to jump on that bandwagon, the high conflict child custody bandwagon. Yeah, you have to be careful, because once something gets popular and once something becomes a thing, that's when other people start to jump on it just because they want to get money. Kelly says there's a lot of attorneys who use father's rights as a buzzword to find their clients. Definitely. The same way food companies use words like natural and homemade and organic. Yeah, LC says most use flying monkeys to do their smear campaigns, thereby keeping a hands-off distance, which keeps them protected, not you. I'm not sure what you're talking about, LC. If you're talking about the X using flying monkeys to do their smear campaigns, it's true, because it's a lot harder to hold the non-parties to the case to hold them responsible. Because one of the things that your ex's attorney will say is that they have no control over those other people, even though really they're just telling him behind your back what to say and what to do. That's absolutely true. Kelly says, in my opinion, if an attorney is a good family law attorney, he or she should be a good father's rights attorney. Well, yeah, they should be a good parents' rights attorney, regardless of the parent. Ecclesiastes, Alex, NARC grandmother also signed her daughters up to an activity that I consider too risky. What do you mean risky, though? You have to be careful with that. My ex tried to say that she didn't want my son going to soccer and swimming because it was too risky in her eyes. And she tried to criticize the school that he was going to. It was a school in Reno, something Bear Swim Academy. And the judge looked at her like she was nuts. So if it's risky, I mean, what do you mean by risky? Are you talking about rugby, maybe even football? I still don't even know if a judge would let you get in the way of football. If you're talking about skydiving or something, maybe. But a lot of judges want the kids to do something extracurricular. You do have a right to make sure it's not being done on your time, though. It shouldn't be. And if it is being done on your time, it should be something that isn't being used to deprive you of your visitation. So if it's something that you have to take the kids to on your time, but you're still getting the kids, that's one thing. I talk about that in the video, extracurriculars. But if it's something that your ex is saying, hey, since the kids are in soccer, you can't have them, that's different. Flyboy C. Alex, what are the top pitfalls for pro se litigants, and how can we win genuine issues in high conflict? I feel we must guide the court to the right decision using best interest law and authorities. You definitely have to guide the court. In fact, I even call it controlling the court. So I use a term that's even more aggressive. You have to, the pitfalls, there's a lot of pitfalls. Most of it is emotion. And your emotion can get in the way. Your feelings could drive you to either take actions that go way too far in court, or sometimes with some parents to not do anything. Some parents have feelings like they feel so bad about their abusive ex that they can't do anything against them because they feel bad for them. Other parents get so angry over something that the court's not going to care about, they file motions and then their ex exploits it. I'm going to get the lighting on. That's better. Let's see here. The other pitfalls aren't even really necessarily your fault. It's bias. There is a huge problem with self-representation bias. You can watch the video because it's not so much a pitfall as something you just have to figure out how to work around. In my opinion, self-representation bias was the strongest, most obvious bias that I saw in the system, way more obvious than gender bias. So you could say that's a pitfall, but really it's just something that it's not your fault, so you're not going to make that mistake. It's just something that the judges do. I'm trying to catch back up to where I was. Some other pitfalls, I would say, is not researching the law. So you would need to look into court rules, statutes, and also try and take a look at what your opponent's attorney is doing. So if they file papers, take a look at those papers and see their style. This isn't necessarily a golden ticket to winning, but at least gives you a hint as to what kind of works. And it gives you something to sort of start off with. That's what I did in my case. I looked at my ex's attorney's papers and pleadings, and I started to sort of copy what she was doing. And then I later on surpassed her, but at least it gave me an idea of what I was supposed to do. And I wasn't relying anymore on common sense. I was relying on rules, statutes, and case law, when I was filing my motions. I was trying to control the court through the law. The other thing I want to say before I move on from Flyboy's comment is make sure that you put research in front of just asking people. A huge pitfall for non-attorneys is they just ask everyone questions. They'll ask clerks, they'll ask other lawyers, they'll ask other people and other friends, and they'll try to sort of litigate their case based on all of the questions that they've asked people and all the answers that they've gotten from them, and they haven't done actual research. So I would say that's a big pitfall, actually. And I did a video on it called Research, which emphasizes the importance of actually going out and finding the answer from the authority itself and not just asking a bunch of random people questions. That's definitely a pitfall in my opinion. Oh, one last pitfall before I move on is learning how to appeal. You have to learn how to appeal. If you don't learn how to file an appeal or a writ petition, you're going to court with a hand and a leg tied behind your back. You really are disadvantaging yourself. So look into how appeals work and learn how to file them, because that is a good 50% of your power as a parent, is filing an appeal. Not just filing them for no reason when they actually have merit, of course, but that's another pitfall. I think a lot of parents don't even think of the possibility that their judge might be wrong. And no, sometimes judges are wrong and you have to figure out how to have their decision reversed. Flyboy, thinking about highlighting narcissism, detail the behaviors. I don't think that's going to actually, I think that might be a pitfall. If you start to focus too much on mental health, you're going to fall down the mental health track. And a lot of parents wander down that track and it goes nowhere. You end up getting evaluations, you end up getting experts involved and spending thousands and thousands of dollars. And then the experts don't pick up on the disorder anyway. I have a video on expert witnesses that goes over an example where a parent successfully did this. And definitely watch that video because you'll see what it actually takes to go down that track and win. It's expensive. It's really expensive, but it worked for this father. Watch the video, Expert Witnesses. Let me know what you think in that video. You can't go this route without expecting an expert to get involved. And as I warn people in the video evaluating mental health, you could go and spend all the money and all the effort and time and still not get the diagnosis from the expert. And now you're worse off than you were before, because now a lot of times the ex will use that as a defense to abuse and neglect that they're committing. They'll say, oh yeah, I did that. That's so wrong, but there's nothing wrong with me mentally. I just made a mistake. It can really backfire. Be careful with that. I would actually classify that as a pitfall. Apyriute says judges don't ever hear about minor problems with police, etc., without motions and a lot of time and money. Well, it's true, but police aren't supposed to be the court and the judge. CPS isn't supposed to be a custody court. So unfortunately, the judges are the ones that are supposed to deal with these issues, not the police and not CPS. I only say that for CPS when it comes to abuse and neglect proceedings specifically, because CPS abuse and neglect proceedings do not have to do with what most people think. Most people think that CPS is there to say, hey, look, there's abuse. We're going to say that it's founded, and then we're going to give the kid to the other parent. That's not really what they're there for. They're there to remove children from situations and place them in permanent care somewhere else. Sometimes it's with a relative, sometimes it's with a foster home, but they're not supposed to get into custody disputes between two parents. In fact, in some states like Indiana, they have CHINS proceedings. If one of the parents is not an offender, then that parent can go to court and say, my child isn't in need of any of your services because I am not abusing and neglecting them, and they can just stay with me. And of course, that is something that I talk about in the video, abuse and neglect proceedings. There is one exception. There is something called an exit order that some CPS agencies can make in some states, and that does allow them to give custody of the child to one of the parents. But that order is kind of, it's not really something it's not really a reason to go through that system, but it ends up being a reason that some people want to go through that system because they figure, well, the agency will do all the work for me and I won't have to spend any money and time. But unfortunately, the agency goes through a different analysis. They're not going through the analysis of which of you is a better parent. They're going through the analysis of, is there abuse and neglect? And with that comes some additional protections to your ex. Like they get a free attorney, they get the clear and convincing evidence standard. definitely watch that video because it's not something I'm going to go into in this live stream because it can go on for quite a while. I think it's a 20-minute video. Jay says, oh, also one last thing, Apyriute, if it's too much money, you might have to represent yourself like I did. Yeah, I did have to file a lot of motions, but at least it didn't cost a lot of money. Jay says, if one parent refuses to ever agree for no good cause to ever allow any extra parenting time, do the courts consider this a form of neglect? No, it's definitely not a form of neglect. It might be something that could be used to modify custody, though, under the best interest factors. But it's tricky because only some judges would even consider that to be an issue under best interest factors. Some judges are going to say, that's the order. And if the other parent didn't let you have extra parenting time, they're still complying with the order. You're still getting the parenting time that you're supposed to have. If you're not getting extra parenting time, too bad, so sad. Some judges have that opinion. Other judges will get, I won't say annoyed or even upset. Other judges might use it when you're trying to modify custody on top of other issues that are much more concerning, or maybe on top of perhaps like a relocation. Like if two parents relocate, or one parent relocates far away from the other, and the court needs to award custody to one of the parents, maybe both of the parents really are good on almost all of the other best interest factors, and the court just needs to find one factor in favor of a parent. That might be when they use something like that, like, oh, they didn't let the other parent have extra time. It's just not it's one of the smallest things that you can bring up. LC says, if those in this arena need help, what I was referring to. Yeah, I got that. Next question is, if my soon ex is on the child abuse neglect registry for child neglect, but has physical custody now before court motions, can I use this to get primary custody? Yes, child neglect does matter. I'm assuming that you're not in court yet, based on what I read. Yeah, if you file like a petition to establish child custody or a complaint for divorce, one of the issues that's going to come up is custody of the child, and you could bring up the fact that they're in the neglect registry. It would be probably a lot better for you to actually find out what precise neglect was committed and bring up the actual neglect that was committed, not just the fact that she's in the registry. I've seen people who've tried to do that and they lost. Next person is LC. Sounds like we are working on something very similar. There's always ways to vet the firms. Yeah, there is ways to vet attorney firms, and it takes time. It's not something that you're going to just ask two people for advice on which attorney to hire, and that's going to be it. Ecclesiastes says, biplane rides and training. Ecclesiastes, yeah, a plane might be something that you might be able to say, I don't want my child doing that. It definitely is a lot more serious than just playing sports. So you should think about, if you don't agree with that, that might be something you want to bring to the court's attention, because that's a big deal. Flyboy C says, Alex is talking about father's rights and buzzwords like high conflict, narcissism, etc. The UK Family Court president is busy with more family court reform. I bet they watch your channel and Dwayne's. Sometimes I feel like the judges here are watching the channel. Not all of them, but there's some of them. Like there was one judge who I saw all of a sudden took an interest in Dr. Craig Childress. I wonder how they found that name out, because that name isn't really that, as far as I've seen, that name isn't really thrown around that much yet. So sometimes I have a suspicion. Prevent PA says, my ex told me I was responsible to take our kids to her and her partner's events on my days. Family events, no, that's ridiculous. If it was an extracurricular, that would be something else. No, it sounds like you have an ex that's trying to control you like you're a babysitter. My ex tried to have me post calendars in my son's room. Like, what? It's not, this is my house. They're just weird. Apyriute says, the child rep and other attorney treat me like crap. I'm assuming you're talking about the child's attorney. And when you say other attorney, I'm assuming you're talking about your ex's attorney. I mean, almost to the point of bar association, RPC complaints. RPC is rules of professional conduct. Child representatives, okay, so yeah, that's a child attorney. In Illinois are immune to complaints. There has to be a way, though. I don't know what to tell you about child attorneys. I've dealt with them I deal with them even right now, because I'm a court-appointed special advocate for abused and neglected children. I don't see them ever appointed in non-abuse and neglect proceedings, but I guess it's possible that somebody in a divorce action or a child custody action has the children appointed a child's attorney. Maybe it's just rare, but from what I've seen, they're so busy. I don't think that they ignore people. I don't know if when you say treat you like crap, I wonder if you mean ignoring you. I don't think they ignore people because they're jerks. I think they're just insanely busy. My understanding is that they represent like 100 kids at a time. Those attorneys have no time to focus on just one kid. Jared Mostel says the judge ordered a custody study. What is the pro and con of this? I don't know what to tell you because I've heard a lot of things from people on what they call custody evaluations. Most of them are negative. I haven't heard of one that jumps to mind that was a positive response from anyone. But the biggest complaint that I hear is that they don't spend very much time on each case. A lot of people have told me that they met them one time for like 30 minutes. A lot of people have told me that they didn't even go to the house. Some people say that they went to the house and just did a quick once over. A lot of people complain that they don't even talk to the kids. Other people complain that they just ask the kids like 5 or 6 questions and left. Some people have complained that they feel like they spend more time filling out the paperwork than the evaluator spends on actually working the case. So most of what I hear on them is negative, but I'm sure it's not like 99%. It's probably like 85% of what I hear is negative. Some of the good situations where I heard the custody evaluator did a good job involved a situation with a personality disordered ex. This is actually the feedback that I got from the viewer I talked about in my last live stream, which was called Viewers Victory #1. He had a custody evaluator that went into the mental health issues that his ex had. And those were substantial. And so that evaluator actually spent a lot of time on the case. Another evaluator in Nevada did a good deal of work on a case involving 2 parents who were really struggling with their emotional issues. And that evaluator even got down into some mental health issues that the mother had. Anyway, I guess it really comes down to getting really lucky and getting a great evaluator. But overall, I get more negative responses on it than I get positive. Mariusz says, what I have experienced is attorneys who represent the dark side of the conflict are also very bad humans. And what is even worse, they are single or after the divorce battle themselves. I think what he means is they're single or in the middle of divorce. Yes, this is definitely true. Personality disordered exes and high conflict parties gravitate towards attorneys who share their attitude. This is something that I have seen over the years. They may not start out with one, but over time, as they're losing attorneys left and right, firing their attorney, getting dumped by their attorney, over time they seem to universally gravitate towards a unscrupulous, crappy attorney, crappy human being. Yes, this is definitely true. And so when they find that attorney who's just like them, it's very easy for them to continue doing what they're doing because that attorney doesn't feel there's anything wrong with it. I do talk about this in part in the video, Win at All Costs. Megan Watson says, it's an expensive rabbit hole to focus on mental health. It is. Megan Watson was able to get primary physical custody by using police. She subpoenaed the police officers. They came to court. They testified. They didn't talk anything about her ex's mental health issues. They talked about what they actually saw. With regards to what her ex was doing. I think it was a domestic violence issue. The police came. They testified. She won. So it's much cheaper, and especially since they're not appearing and testifying as experts, they're just appearing to testify as a lay witness. So it's like $20 a pop, and you get them in, and they talk on the stand. The judge listens, and she did a great job getting custody of her kids. And it was a lot cheaper, and it was a lot easier. She didn't even use an attorney. She did it by herself. Pyre says, we have to be careful about calling out psychological personality disorders. It's a trap and probably not appropriate, even if the behaviors are obvious. Pyre, absolutely true, and that's what I talk about in evaluating mental health. That's exactly what I warn people about. Let's see, LC cases. Those cases are a min of $100,000. Yes, I talk about this, LC, in the video, settlers versus litigators. If you actually do get a litigator attorney, you will be spending at least $25,000, at least, $25,000. If you're going to get experts involved and you're going to go over mental health issues and stuff like that, it will balloon up into the 6 digits. My case was so contentious that if I had an attorney all the way through, I would have easily spent between $250,000 and $750,000 because it was so much paper and it was over 20 hearings. There's no way to get through the family system with an attorney going through 20 hearings, 3 different cases, multiple appeals without spending upwards of almost $1 million or even actually spending $1 million. Kay Nelson, how can judges in family law be educated on the long-term effects of children from cluster B parents? Kay Nelson, this is a great question. I talk about this question in the video discretion, and I have a great answer for this question. The answer is you can't. You can't educate the judges on it because there are way too many judges and they turn over and get replaced by judges so frequently. What you can do, however, is you can educate the legislature. If you educate the legislature on those issues, the legislature can in turn fashion statutes that control the judges, that bind the judges, that twist the judge's arm into doing what they're supposed to do. If you can get the legislature to look into those issues and put together statutes with regards to how family dynamics work with one of those types of parents, you can control the court through the statutes. And what I mean by that is when there's a statute, if the judge doesn't follow it, the Supreme Court will fix their wagon. They will reverse that judge's decision and send it back to them. I've done this many times in my own case. I've won 4 appeals. What I needed to win my appeal was statutory language. I didn't need the judge to be educated because the judge can get educated and then get swapped out with another judge, or the judge can get educated and then get sick and then a senior judge has to come in, or you'll get a pro tem judge that comes in that doesn't know anything about what's going on. The judge can get educated and then have preconceived notions, or they could have they could just be ambivalent towards it. What I mean by that is they might just think, oh, that nonsense isn't true. So you need to control the judge through the legislature, through statutes, and not send them to training. That's not the right approach. It won't work. And then, of course, using the appellate court when the judge refuses to follow the statutes that were created. Using the appellate court to force the judge to make the correct decision through an appeal or through a writ of mandamus. Pyriu says, if you don't know what that is, watch the video, writ petitions. Where was I? LC says, there are already some efforts going on in this arena. That's true. But I don't think it's going to go very far. Educating the judges is just a waste of time, in my opinion. You know, if the judges want to learn on their own, that's great. Any judge who's like, I want to learn about personality disorders, that is a great judge. But if you're going to just tell all the judges you need to go to school, you know, it's going to be the same thing as if with the public schools, all the kids that are going to school, some of them are going to listen. Some of them are going to just say, why am I here? It's a waste of my time. I want to go home. And they're not going to care and they're not going to listen. So it's better to just educate the legislature and get a series of statutes that controls on that issue. Yeah, Apiri, focusing on the behaviors is easier. You can't really diagnose them. You should still evaluate them because evaluating them is helpful to trying to figure out what's going on in their head. It's helpful to you as a person to try and understand them. And it doesn't necessarily mean you have to agree with their broken thinking, but at least if you understand it, you'll be able to see where it's coming from. You'll be able to anticipate it. You'll be able to work around it. You'll be able to analyze it better. And then, of course, using the symptoms of their disorder, which are symptoms that trigger or that are abuse and neglect, and of course, bringing those to the court's attention to modify physical custody or legal custody. Apiri says many litigants filed protective orders which require quick action and not enough time to attorney shop. Well, what I can say about protective orders is they're not really supposed to impact custody cases anyway. In Nevada, they don't really do so anymore. My ex got a protective order against me and her parental rights got terminated. So what does that tell you about how great those are? Protective orders are supposed to be a really quick fix for domestic violence, and that's it. If somebody is threatening domestic violence, you get a protective order that tells them to stay away. That's all they're supposed to be for. But people try to use them for all kinds of other weird things, like when their ex is upsetting them about what they're doing with the child, taking them, on their custodial time. Like, what? That's not what a protective order is for. That's for domestic violence. You're just upset that they're not letting you see the child. That's a valid concern, but you don't solve that with a protective order. You solve that with a contempt of court order. So they just get abused for all kinds of random things that make no sense. Maybe other states still use protective orders. I'm not going to say as a basis to modify custody or to deprive a parent of custody, but maybe they still let them sort of affect their decision making. But I know in Nevada, it's not really, they don't really do that anymore. A judge will say, okay, well, you got a protective order. You're going to still have to prove that they did something in this court. They're not going to just take your protective order and just believe it and give you everything that you're asking for. Those are the old days in Nevada. Those days are long gone over here. Yeah, Megan Watson says they're expensive and many are unqualified. I think what you're talking about is mental health experts. Yes, you're so right. You should, everyone who's curious about getting the best expert for mental health, watch the video Expert Witnesses, because the viewer who won his case brought up some really interesting points, and he's absolutely right in how he approached finding the right expert for his case. Very insightful advice from that viewer. LC says, will a custody evaluation require a MMP-12? I don't know what an MMP-12 is. Let me know what that is. Pyre says, child representatives, GALs, are almost automatically appointed in Cook County, Illinois, in any case involving kids. You know what, Pyre, that may be because your state has more resources, and it may be because you actually have more money, or it may be just because you don't have as many people that are in child custody conflicts. If that's the case, that makes more sense as to why you have. Oh wait, you're saying it's a child representative, so a guardian ad litem. That could be good or bad. Do you guys have to pay those guardian ad litems? Definitely let me know, Pyre. If those are free GALs, that's one thing. But if you're having to pay those GALs, let me know, because that's bad. That's gonna. Some parents don't have the money for that. I thought you were talking about child attorney. A child attorney is very different from a guardian ad litem, and I have videos on both. I have a video on child attorneys, and I have a video on guardians ad litem. Flyboy C says, K. Nelson, I think the family court will wake up to these issues and false allegations, protective orders within 10 years. The zeitgeist has to change for children's mental health. Flyboy in Nevada, they've already figured out all about the false allegations with temporary protective orders and protective orders. It's already well known here throughout the judiciary that people, not all people, but a lot of people file those just because they want to get an advantage in their custody case, or just because they want revenge. So in our state, we're already there. We've reached that point. There's judges here who just flat out deny protective orders. And there's other judges who, like I said, when you get into the family court and they see that there's a PO, they're not very impressed. They'll just ask, is the other person abiding by the PO? Yes? Okay, let's move on. They don't want to talk about it anymore. As long as you're complying with it and you're staying away, they don't care. And it oftentimes does not impact the custody decision. If that parent has issues with domestic violence, they're going to have to prove those issues in that child custody case under the clear and convincing evidence standard, which is one of the best standards in family law. Doesn't apply in all situations. In fact, rarely ever applies. But in one of them, allegations of domestic violence is one of those situations where those allegations have to be proved by clear and convincing evidence. Family law has a bad reputation. Well earned. It's those bad people who write the statutes, chair professional associations, and graduate to family judges get used to it. Pyre, I agree with you mostly, but not fully. Most of the statutes in the family court system do make sense to me. There are some that are obviously messed up, though. And what I'm talking about is the ones that talk about awards of attorney fees. I feel like those attorney fee award statutes are despicable, and that they serve to line the pockets of the attorneys. I have no issue at all with the standard attorney fee as a sanction statutes. Those make sense to me. Those statutes require you to prove that your ex is harassing you, filing motions without any reasonable basis, stuff like that. But the other statutes that just allow the judge to award attorney fees just at their discretion, those are definitely, in my eyes, those are despicable statutes, and I don't think that those should be in place. But my opinion is that most statutes actually do make sense. Professional associations, I'm not sure what you mean by that. We don't really have, I don't see that we have those here. Do bad lawyers become family judges? I think probably, yeah, about half the time, but I don't think all of them are. I think there's a lot of them that want to do the right thing, but they feel cornered by the attorneys. And then there's a small handful of them that are just great. And then, of course, there's a small handful of them that are just corrupt. There is a large portion of them that just, it's a paycheck to them. I talk about this in the video, Good Judge, Bad Judge. Do mental health conditions in and of themselves do anything for custody? For example, if one parent has a bipolar but taking medication, No. In fact, with that example, if a parent has bipolar disorder, and that's not even a personality disorder, that's just a disorder. If a parent has bipolar disorder and they're taking medication, that should not impact the custody decision, because the medication is supposed to take care of the symptoms that come from it. So it's a different story if they're not taking the medication, though. I think I talked about that in the video. Oh, I don't know if I talk about that now. I think I talked about it in the video addictions, but I'm not sure now. You might want to check into that. Apyriute says protective orders automatically modify reallocation of parental responsibilities. Mine was vacated and the extreme modification has lingered for over a year. Can you let me know what state you're in, Apyriute? And also if you could send me a copy of the protective order. But in Nevada, they don't do that. Patrick says you have to pay the GAL. Oh, also, Apyriute, let me know if that protective order was entered after you had already gotten an order from a custody court. If you did not have an active custody case open and the protective order was your first contact with the court system, that is something that does happen in Nevada. The protective order will set the custody rights, but what you're going to have to do is go to family court and actually get those fixed. Patrick says you have to pay the GAL in Illinois. See, that's not right. What if a family can't afford to pay the GAL? Do they just make one parent pay it all? And that's just going to make the high conflict parent drag it out because they're going to want to see that your finances are destroyed. So that sounds awful. Apyriute, child representatives, GAL attorneys for child are paid by the parties. Wow, that's messed up. In Nevada, that's not a thing. You can ask for a GAL if you want one in Nevada, but you don't have to have one. You can ask for a parenting coordinator, but the other party must agree. If the other party does not agree, the court cannot appoint a parenting coordinator. Child attorney, like I was saying, they don't even really get used at all, with extremely rare exceptions, possibly. I haven't even heard of that before. So it's just very different here, I guess. Maybe some of the other states that they still have to catch up with us. LC says it's an MMP-12. It's a forensic psych test. Okay, yeah. Those are not routinely ordered in Nevada, but you may be able to get them ordered. Again, that's going into some of the dangers of going down the path of proving mental health issues through an expert and through diagnosis. Apyriute says the child attorney's GALs are ultra mercenary and will shake you down. Yeah, I can imagine. I've heard stories. When you owe them money, I've heard. That's why I'm not really big on them. You know, anything like that, unless the parties both make 100 grand, to me, that doesn't make sense to use them. And even then, I'm not sure that it's a good idea. You know, they try to create all of these extra things to sort of help the court, but sometimes all it does is unnecessarily complicate the issue. And when it comes to a high conflict X, the more people that are involved, the more attack surfaces that they have to latch onto. All it does is give them more people to potentially exploit and convince. So for me, what I tell people is, in my opinion, if you have a high conflict X, the less decision makers you have, the better. One judge, that's it. Because that minimizes their ability to communicate with all these different people and sort of feel out which of them is the weakest link, and then get buddy-buddy with that one person. That's what they do. The child attorneys, oh wait, here we go. Apyriute says statutes and court rules account for about 10% of dispositions in family court here in Cook County. The rest is cultural, it's complex. Apyriute, that may be a problem with discretion. Watch my video on discretion. In Nevada, we had a very similar problem in the past, but there's a bunch of new statutes that have come out that force the courts to do certain things that they didn't have to do before. And there's also new statutes that even force the courts to explain their decision. It sounds like some of the other states need to sort of catch up to us here. But in Nevada, the Supreme Court and the Appellate Court, the Court of Appeals, they will reverse decisions that are in violation of those statutes. They will reverse decisions that don't even explain their reasoning. I've seen them say, we don't even know what the judge made his decision based on. Because of that, we're going to reverse, and we want the judge to enter an order that explains why they made this decision. Yeah, absolutely, it's a problem if you're in a state that doesn't have some basic statutory controls in place for the judges. If your state just lets the judges just do whatever they want in family court, you're absolutely going to have incompetence on a mass scale. And that sounds like what's going on. LC says, yep, an MMP-12 forensic psych test will expose the behavior issues without you bringing it up. That's interesting. I need to learn more about that because I didn't know that was a thing. James the Broviver says, what's up? What's up is we're doing a live stream. Minnesota says, or wait, Apyriute, Minnesota multiphasic personality test. Okay, that sounds like it. That's the acronym. How's it going, Shane? Richard L. Regarding selling house post-divorce decree spells out equal proceeds. I paid the mortgage since the filing of the divorce up to now on the market. Would I be entitled to mortgage payments, principal payment credits? That's a good question, Richard. Unfortunately, I didn't have a divorce because I didn't marry my ex and we didn't own real property. So I never went through that, so I don't know the answer. But if you send me an email, I may look into it. Flyboy C says, thanks for the great live stream, Alex. Good night, off to bed. Thanks for coming. It's good to see someone from the UK here. Hit the likes. Yeah. It looks like we're almost done here. Actually, it's a 1 minute past the time that I was going to put into it. So I'll take one last question if somebody has one. And after that, I'm going to go ahead and head off. I'm going to schedule my next live stream on the website. You'll be able to log into the website. You don't even have to log in. You can just go to the website, theproperperson.com. The homepage will have the next live stream schedule, which I'll set up probably after I get off of here. I'm going to stick to Saturdays and Sundays. It seems to be working out. Hopefully next time we don't have that weird issue in the beginning with the chat not working. LC, so that's going to be my last question. LC says, how do we connect directly with you? You can connect directly with me by sending an email to admin@theproperperson.com. Yeah, with that, I'm going to go ahead and see you guys next time. Thanks for coming on. I'm going to try to figure out how to get YouTube to send you guys notifications at least 15 minutes, hopefully even a couple hours prior to me going on. Yeah, but with that, I'll see you guys next time. Thanks for coming, and goodbye.